I'm pleased to welcome Gillian Thomas to Politics and Prose. Ms. Thomas is a senior staff attorney with the American Civil Liberties Union Women's Rights Project. She has been interviewed by NPR, the New York Times, and the Wall Street Journal, and her work has appeared in Slate and The Atlantic. Thomas's book, Because of Sex, details 10 legal cases that fought against sex discrimination in the workplace, some all the way to the Supreme Court. Although Title VII of the 1964 Civil Rights Act banned discrimination because of sex, it took these brave trailblazers to make sure all employers, then and now, continue to heed those words. As Clara Bingham, co-author of Class Action, the landmark case that changed sexual harassment law, says, elegantly written and vividly described, Because of Sex tells the fascinating story of America's accidental feminists, the women who, because of circumstance and courage, changed long-held perceptions of what Americans thought women were capable of. It is a must-read for anyone, man or woman, who puts on a uniform or a suit and goes to work every day. Oh, and this Sunday, Because of Sex will be listed as one of the New York Times' new and noteworthy paperbacks this Sunday in the Sunday Times. Now, please join me in welcoming Gillian Thomas.
Hello. Thank you all so much for coming. It's so wonderful to see so many familiar faces, parents. Those are the most familiar. Friends, old and new, coworkers. So thank you all so much for being here. This is a really great day. It's the paperback launch of Because of Sex. So it's a very exciting night for me. So thank you for being here to share it with me. What I'd like to do is tell you a bit about what Title VII is, and then talk about a few of the stories of the women in the book, and then hopefully leave plenty of time for questions. So as you heard from the introduction, Title VII is the section of the 1964 Civil Rights Act that deals with employment, and we're all familiar with Title VII as being, or with the 64 Civil Rights Act as being the culmination of decades of literal blood, sweat, and tears by the African American community to achieve an end to discrimination, at least insofar as the black and white law was concerned. And so there were many sections of the 64 Civil Rights Act. They were called titles. They dealt with housing or public accommodations, those white and colored water fountains that we're also accustomed to seeing in pictures. And the section that dealt with employment was Title VII. Now, as written, the title dealing with employment discrimination originally outlawed discrimination on the basis of race, national origin, color, and religion, but not sex. Many felt that it was that sex deserved its own law, that this was the race bill, and that should be something different. But on the last day of floor debate in the House on February 8th, 1964, a virulent racist from Virginia, Representative Howard Smith, an octogenarian, avowed segregationist and opponent of the Civil Rights Act, rose and said that he wanted to add sex to the list of protected characteristics, which garnered a great deal of laughter. It was unbelievable, unthinkable, maybe after the sight of Bull Connor and German Shepherds attacking children in Birmingham, maybe people were willing to think that there should be a law promoting anti-discrimination principles as far as blacks were concerned. But to say that women should be free from discrimination in the workplace literally was a joke. The floor erupted in laughter. Male representative after representative got up to talk about how hilarious a proposition this was. And then finally, Martha Griffiths from Michigan stood up, and I'm paraphrasing, but she stood up and she said, if there were any doubt about women's second-class status in this country, I think that laughter would have dispelled it. And things got kind of quiet, and debate continued in earnest. And people have debated, and ultimately it passed by voice vote and then passed without much fanfare in the Senate and became law. People have debated over the generations what Howard Smith's motives were. And some have said it was a joke. Smith himself sometimes said it was a joke. Others have called it a poison pill, meaning that that even if people were willing to enact protections for blacks, that they would never do it for women, and that would sink the bill. And so that was a way to get the bill denied. But as is often the case, the truth is really much more complicated and not especially pretty for Howard Smith, at least. But he actually, incongruously, was a supporter of the Equal Rights Amendment, which had been bouncing around Congress for several decades at that point. And the National Women's Party came to him and said, listen, if we have this bill go through, think of the consequences. Black men and black women are going to have more rights in the workplace than white women, and we don't want that. And Howard Smith didn't want it either, and Martha Griffiths, in her wisdom, wanted equal rights for women in Title VII, and so she joined forces with Smith and used him really as the vehicle to bring the sex amendment to the floor, and ultimately it was passed. But what we were all left with was terrific, good news. We have sex discrimination in employment that's prohibited, but what on earth does that mean? There had been no committee hearings. There had been no amendments or proposed amendments that had been shot down. There had been no committee reports or testimony or markups. And so Title VII sex provision was birthed, if you will, into the world, into a world that had sex-segregated want ads, help wanted men, help wanted women, where sexual harassment didn't even have a name yet, let alone any sort of conception that it should be against federal law. Just a few years earlier, a little over a decade earlier, the Supreme Court had upheld a state law in Michigan that women could not be bartenders unless their husbands or fathers owned the bar. And women were still not being required to serve on juries because their duties at home were considered more important than their civic duty. So into this world came this law, and what on earth was it supposed to do? The EEOC, the Equal Employment Opportunity Commission, my former employer, which I have nothing but the greatest pride for now, and pride for that service, but they did not cover themselves in glory in the early years after Title VII was enacted. The head of the EEOC joked that Title VII, or that the sex provision, was a fluke conceived out of wedlock. And they had no intention of really enforcing it. They saw this as a race law and the sex provision as a joke. And so into this murk, into this lack of clarity and lack of mandate, came individual women and their lawyers who realized that this law was there for a reason and decided to take cases to court to give essentially contours to these bare bones 3 words, because of sex. And so that's where this story begins. And I, as an employment lawyer, rely on the cases that are in this book all the time. They're sort of the brand names, if you will, of employment discrimination. A client comes in with a sexual harassment claim. Oh, well, that's Meritor Savings Bank versus Vinson, and then also Harris v. Forklift, both in the book. A woman comes in, as is sadly so often still the case, comes in and says, I don't think I got a promotion because I'm a mother. It went to a man who has no children. That's the Phillips v. Martin Marietta case, which is the first case in the book. But the women who brought these cases didn't have those brand names. They had this murky 3-letter word, this 3-letter word, bare bones thing to hang their fates on. And that takes incredible gut and incredible grit and courage, as it did with the lawyers as they made their way forward. So that's why I wanted to write the book, to give, to pay homage to them. I want them to be as famous as Anita Hill because of what they did for just as many, if not many, 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 many more women. And for me, both as a woman and as a practitioner. So moving into the discussion of the book and the substance that I covered, I think you can break the cases down into 3 general thematic areas, 3 aspects of women's identities as women that have collided pretty much constantly and frankly continue to collide with their identities as workers that employers and judges and juries and lawmakers and lawyers and all of us have had to grapple with. But in the process, I think that Title VII, it's really not an understatement to say that the law that was created by Title VII really changed what it means to be a woman, and as a consequence changed what it means to be a man. It really had extreme cultural significance. So the three areas, pregnancy and motherhood. What does equality look like when you have actual physical difference? It's undeniable. Women have children, men don't. And it's also undeniable that as much as we may wish that the balance changes, women are caregivers, the primary caregivers in most families as well. So what does equality look like? What does it mean when we're talking about the intersection of pregnancy and motherhood and employment? And the second theme I want to talk about is stereotypes. Not just stereotypes that were reflected in those want ads, help wanted men, help wanted women. The stereotypes that there are just certain kinds of work that men are supposed to do and certain kinds of work that women are supposed to do. But then even more broadly, what does it mean to even be a woman? Is there a certain way you're supposed to look or act? And those kinds of stereotypes about fitting us all in boxes. You think about the flight attendants in the 1960s who were getting fired if they reached a certain weight, or were getting fired if they got married or became pregnant when they stopped fitting the stereotype of being a sexually available, essentially cocktail waitress in the sky, right? Fluffing pillows and lighting cigars. Moving away from that narrow conception of what a woman is supposed to look like, what is an employer allowed or not allowed to dictate in that regard? And then finally, but last but certainly not least, the issue of sexual harassment, which, as I mentioned, literally did not have a term that was assigned to it. That didn't happen until the late 70s, but also was just simply so ubiquitous as to be part of the air women breathed. I speak to people of my mother's generation who worked during that time and talk about it's just the way it was. And you just didn't even think about it, the insults, or you just laughed it off because that's what you were supposed to do. You couldn't imagine it being any other way. So the development of the law around sexual harassment, while certainly not eradicating sexual harassment, as we know from current headlines, and P.S., this book is a celebration of what these women have achieved, but it is by no means meant to signal that we're done with these problems. We don't have to worry about them. Only that these women in these cases gave an architecture for how we can now think about them and solve these problems. So I'd like to talk very briefly about three cases that illustrate these themes that I'm talking about, and then hopefully we'll have time for some questions. So the first area, the pregnancy and motherhood, I'm actually going to start with the first chapter in the book, which also was the first Title VII case ever decided by the Supreme Court, not just under the sex provision, but at all. It was decided in 1971, Phillips versus Martin Marietta, and I'll read a brief excerpt and then continue the discussion. On a hot Florida night in September 1966, Ida Phillips sat down at her kitchen table to write a letter. Her small frame bowed over a tablecloth printed with green and orange flowers. She quickly filled 3 small pages with her tidy cursive. To the President of the United States, she wrote, as of this date, September 6, 1966 at 7 p.m., I answered an employment ad of Martin Company of Orlando, Florida, in which the company seeks 100 assembly trainees. However, after completing my application, I was told by the receptionist that my application could not be honored due to the fact that I have a preschool child. A neighbor had alerted Phillips to the newspaper notice placed by the Martin Marietta Corporation, a missile manufacturer with a sprawling facility 10 miles from downtown Orlando. With a workforce numbering in the thousands, it was one of the largest employers in the city. Entry-level jobs on the assembly line paid up to $125 a week, more than double what Phillips was earning as a waitress at the Donut Dinette. Even better, the job came with a pension plan and benefits, including insurance. You'd better get down there early, the neighbor advised. There's going to be a lot of people over there looking for that job. Phillips resolved to be one of them. 32 years old and the mother of 7 children ranging in age from 3 to 16, she was barely scraping by. Every day she counted up the tips that she'd made during her shift and decided what she could afford to buy for that night's supper. The little bit she had left over got tucked away to cover the bills. She certainly couldn't count on the wages her husband, Tom Phillips, got from working as a mechanic. Those he usually drank. So Phillips, a vivacious, dimpled redhead, had driven the 10 miles to the Martin Marietta facility on Kirkman Road to submit an application. When she got to the front of the line, the receptionist asked her if she had any preschool-aged children. Hearing that Phillips had a 3-year-old, the woman declined to let her apply. I felt like the world had caved in on me, Phillips recalled. I had my hopes up so much for it. She needed those wages, and her kids needed those benefits. That's when Phillips decided to write President Lyndon Johnson. My President, may I say that I believe that this is unjust from the policies that you have administered during your term of office, she implored, as equal opportunities, as equal employment and constitutional rights. Phillips hadn't grown up paying much attention to politics, but she recently had registered to vote and, in her words, started reading the papers cover to cover. She may not have known specifically about the 1964 Civil Rights Act, but she plainly suspected that Martin Marietta was doing something unlawful. Phillips' daughter, Vera Tharp, remembered that when their neighbor stopped by that night to check how Phillips had made out, he was incredulous. After all, he worked for Martin Marietta, and he had kids in preschool, and the company had never objected. Less than a week after she'd put her letter in the mail, Phillips got a response from the White House. Her complaint, she was told, had been forwarded to the U.S. Equal Employment Opportunity Commission, the federal agency tasked with enforcing Title VII, for further investigation. The following summer, the EEOC issued a decision in Phillips' favor. In November 1967, having tried unsuccessfully to convince the company to settle the case by giving Phillips the job she'd applied for, the EEOC mailed Phillips a notice telling her that it had done all it could, but she had the right to continue the case on her own by filing a lawsuit in federal court. Phillips definitely wanted to press on. She was too angry not to. Now, she needed to find a lawyer. This is Ida Phillips and 6 of her children. After, we have some mood lighting going on. After the case was brought and eventually was decided by the Supreme Court, Phillips did find a lawyer, but it took a little time. She went to a couple of white lawyers. As you can see, she's white. She went to a couple of white lawyers who, in her words, said they didn't think it was much to fool with. And so she then thought, who would know how to bring a civil rights case? I'll bet a black lawyer would know how to do that. And so in 1968, Jacksonville, she set out to find a black attorney. And there was a black attorney running for judge in Jacksonville. And she went to see him, and he said, well, I'm too busy with the campaign, but I have this young guy who just finished an internship with the NAACP Legal Defense Fund in New York, and maybe you should talk to him. And that was Reese Marshall, who I was privileged to get to meet with. He still practices in Jacksonville. And he was 25 years old. And this shows you how little of a ripple the sex provision had made in the public consciousness. Here's an attorney practicing civil rights law, and after he met with Ida Phillips, he told me she left his office. He had been nodding along with what she had to say, and he had to go and pull the statute book down from the shelf and look it up, and he said, well, there it is. It was sex. It's right in there. Who knew? So he took her case. They lost at the lower court and at the appeals court. The problem was that Martin Marietta's workplace was 70% women. 70% of the assembly line workers were women. They just either had no children or had older children. And so the company's defense was, how can we be discriminating against women? We hire mostly women. And it's just this subset that we don't want to employ because they're unreliable. We have found that they are tardy more often. They're absent more often. Fathers, we don't have to worry about, but mothers with young children, we do. And the tipping point, what took the case to the Supreme Court and what got Ida Phillips the representation of the NAACP Legal Defense Fund at the Supreme Court level, was a vigorous dissent at the Fifth Circuit middle appellate level, where the judge who wrote the dissent said, look, if we take all of the protected characteristics under Title VII and allow employers to carve out groups of them by adding on these seemingly benign subgroups, Blacks who are left-handed, we're not going to hire. Jews who don't have a college degree, we're not going to hire. If you allow these plus factors, sex plus, race plus, to stand, the act is going to be Swiss cheese. There are going to be exemptions upon exemptions, and it's not going to mean what it says. And in his famous words, he said, if sex plus stands, the act is dead. And so with those words, Reese Marshall was able to get the NAACP Legal Defense Fund interested, in part, not just because they saw the overall threat to Title VII in the way that I just described, all the categories being carved out, but most working mothers at that time, as is still the case today, were black women. And so if this ruling stood in Ida Phillips' case, it was going to affect millions and millions of their direct constituents. And so the case went to the Supreme Court, and if you ever want to really geek out, you can listen to oral arguments online at a website called oyez.org. And when you listen to the oral argument of the Phillips case, I can't go into all the details here, but it is incredible how befuddled the justices were by the sex provision. I mean, this thing had been law for, 1970, so 6 years at that point. And you have Harry Blackmun, who became a feminist icon 3 years later with his Roe v. Wade opinion, asking Bill Robinson from the NAACP Legal Defense Fund, and Bill Robinson, by the way, is a professor here at UDC Law School, and I spoke to him for the book as well. You have Justice Blackmun asking, now let me get this straight. If you have a hospital that hires female nurses, just because, that's what they've always done, and then a man comes and wants to be a nurse, does the hospital have to hire him? And Robinson said, yes, Justice Blackmun, that's what it means not to discriminate on the basis of sex if he's qualified to do the job, yes. And then you have Hugo Black saying, okay, wait a minute, what about digging ditches? What if you have a woman comes in and wants to be hired as a ditch digger? Does the super on the job have to hire her? Yes, that's what I'm talking about. Can't use sex to determine whether you hire someone if she's qualified. And then we have Chief Justice Warren Burger, who pipes up to ask, with some concern evident in his voice, this law doesn't apply to federal judges, right? Does it? And it did not at that time. The law had to be amended in 1972 to apply to state and federal employers. And so Bill Robinson assured Chief Justice Burger that it did not. And he said, no, I didn't think it did. And then you hear him, this is probably the most extraordinary thing for me. This is in my lifetime, the Chief Justice of the Supreme Court, after asking the lawyer for Martin Marietta about this 70% women workforce and what kinds of jobs all these women were doing. The lawyer for Martin Marietta said, well, it was very small work with their fingers, very intricate electrical assembly. And Chief Justice Warren Burger says in open court, oh, well, that makes sense that women are good at it. That's why they're so good at typing. That's why they make such good secretaries. Anyway, the court came down with a ruling, and this is very typical of the early years of the Title VII jurisprudence, saying any rule that says, one rule for women and one rule for men, yes, that is sex discrimination. They did remand the case, showing how far we had to go. They did remand the case to allow Martin Marietta to prove at trial that as an empirical fact, mothers of small children were more unreliable than other workers. Thankfully, the case settled before that hearing ever had to be, we had to be subjected to that hearing. As for Ida Phillips, sadly, it turned out, when they settled the case, it turned out that the position she had applied for had actually been subject to a layoff shortly after she had applied, and so her actual out-of-pocket losses were actually not that high. She would have been laid off if she had been hired. So she got $15,000 in back pay, and she used a third of it to take Gracie, the source of all the problems, down there in the corner, took her to Disney World. She gave her oldest daughter, Peggy, a down payment on a house, and with the last bit of money, she bought herself her first air conditioner that she'd ever had in Florida. Stereotypes. This is Ann Hopkins. Ann Hopkins in the late 1970s and early 1980s worked at here in DC at the Big 8 accounting firm of Price Waterhouse. She was a consultant in their government affairs department. And she went up for partner in 1982. She was the only woman out of 88 candidates to go up for partner. She also had the biggest book of business and had the support of her department, the government relations department. She was not turned down, but deferred to the next year. And she went to meet with the head of the firm to find out what had gone wrong. And he started reading her the reviews that she got from the partners who were making the decision about her partnership. And they said things like, macho, swears too much for a lady partner, overcompensates for being a woman, needs a course at charm school. She went to her mentor at the firm and said to him, I don't know what to do about this. I had the biggest book of business. My clients love me. Nothing is wrong with my work. It's just me that they don't like. What am I supposed to do? And her boss, thinking he was being helpful, said, well, why don't you try to walk more femininely, talk more femininely, wear makeup, get your hair styled, and wear jewelry. She bought a pink suit, you guys. She did try. She bought a pink suit, and incredibly, that didn't do it. And in fact, the next partnership decision time came around, and she was not even put forward this time by her department. So she got an attorney who still practices here in Washington, Doug Huron. Jim Heller sadly passed away before I could meet him, and got lawyers and eventually quit, and they filed a lawsuit. And Doug Huron had a brilliant stroke, which was he knew that social science, social psychology had been utilized in race discrimination cases, especially most famously the Brown versus Board of Education case, to illustrate to the judge, and at this point it was just a judge, there weren't juries hearing Title VII cases until 1972 when the law was amended, or excuse me, until 1991 when the law was amended. But he knew that social science and social psychology had been used to explain to judges how discrimination is felt by its victims and also what leads people to discriminate, sometimes without knowing that they're actually doing it. And so he enlisted the services of a young social psychologist at Carnegie Mellon, Susan Fisk, who had done research in this area. And she read all of the reviews, all the evaluations, and she wrote an expert report that said that this decision was infected by stereotypes, stereotypic bias, both prescriptive and proscriptive stereotypes. Prescriptive meaning women are supposed to look and act like this with the earrings and the makeup and the nice pink suits. And proscriptive stereotypes meaning they are most certainly not supposed to use four-letter words or be brusque or act macho. And they got very lucky because Judge Gerhard Gesell, who heard the case at the lower court level, was the son of a child psychologist. And he got this. And he found in Ann Hopkins' favor. And it went up to the D.C. Circuit, and the D.C. Circuit found in Ann Hopkins' favor. And then it went to the Supreme Court. And the ruling is a very convoluted ruling for other reasons about the burden of proof that the parties have about causation. And so there was no unanimous or no majority opinion that came out of it. But one thing that was unanimous was that relying on stereotypes to make decisions is sex discrimination. Sex-based stereotypes is sex discrimination. In other words, punishing Ann Hopkins and denying her partnership for being the wrong kind of woman was just as much discrimination and against Title VII as denying her the partnership because she was a woman, full stop. And this was revolutionary. And it was amazing to me when I met with Ann Hopkins, she really did not grasp the significance of this case, because not only did it obviously make the workplace a more equal, equitable place for women like her and men like her who didn't conform to stereotypes, but then also it's been used more in the modern day and ongoing to protect LGBT individuals on the job. Because what is more of a gender stereotype than men are supposed to be attracted to women and women are supposed to be attracted to men, or that the gender you're assigned at birth is supposed to be the one that you stick with your whole life and you're never supposed to look or act or be anything else. anyone else. So it's a major decision. It's relied on all the time in our work. And in fact, stereotypes of all kinds have been acknowledged as discrimination, including, in a nice dovetail with our friend Ida Phillips, discrimination against mothers because of biases, just like the ones Martin Marietta held, that mothers are going to be less committed, less dedicated, less willing to travel, and so on and so forth. Pretty well. Surprised. On time. Okay, last. Sexual harassment. Michelle Vinson. She is the only woman, only subject of the book who is still living, who did not speak with me. And I totally understand why. She didn't ever tell me why, but I can guess and I understand, which is the facts of her case and this chapter of her life are pretty grim. And I can understand not wanting to revisit it. So I, in this part of the book, in this chapter of the book, relied on 3 of her attorneys, interviews with them, as well as court documents from down here in D.C. Can I just tell you fun trivia that I just learned, by the way? I was assisted by it was in the district court here in D.C. where her trial was heard. And the clerk there who helped me dig up all the boxes to look through and get transcripts of testimony at trial or deposition testimony, which was amazing to look through. The trial was in the early 1980s, is Justice Ginsburg's trainer, which I didn't realize until he's a Marine reservist or Army reservist, and I just am so mad I didn't know that at the time, because I would have made the book about something totally different, let me tell you. Anyway, Michelle Vinson, 19 years old, grew up in Southeast here in Washington, African American, obviously, from a very, very impoverished background. She ran away from home at least once, intentionally got pregnant at age 15 by a friend of the family because then she could marry him without needing her parents' permission. She eventually lost the pregnancy. And she saw the manager of her local bank where she had her checking account, and Sydney, oh my gosh, I can't believe I'm blanking on his name all of a sudden, but she saw him in the parking lot one day and said, could I be a teller? And he said that she could, and she came into the bank, and he taught her in the ways of banking, and she excelled at the job. In the first 6 months, Sydney Taylor. And in the first 6 months, she did great. She was a little alarmed by how Mr. Taylor, which is what she called him to the last day of the case, and by the time, and to the time she was interviewed by reporters after it was over. Mr. Taylor, it did bother her that she saw him touching other women and saw them flinching from him, and that concerned her, but he was nothing but professional with her, gave her money when she needed it, when she was short for rent. And then after about 6 months, he took her out to dinner one night, which was not unusual. They had gone out to dinner with other coworkers. And he took her out to dinner and he said, "You are going to have sex with me tonight," although those are not the words he used. And he said, "I made you and I can break you." And she also says that he threatened her life. And so she succumbed. She acquiesced. And she continued to acquiesce for 3 years. And she only finally got an attorney. You have to understand, at this time, no one had a sexual harassment policy. The words sexual harassment weren't used broadly. There was an anti-discrimination policy in the bank. Sydney Taylor was the person you lodged your complaints with at the bank. And this is also this is her first professional job. She has no other skills other than what she's learned at this bank, and she has had her life threatened and she's petrified. And also, as she said in one interview, didn't know that relationships really could be any other way than this was. And so she finally was getting a divorce and went to see a divorce lawyer at a little law office in Georgetown late one night and broke down. And the lawyer patted her hand, their divorce is sad, I know. She said, "It's not the divorce, it's my job." And for the next 2 hours, Michelle Vinson poured out her heart to this attorney who herself was only a couple of years out of law school, who was sure this must be illegal. And so she referred Michelle Vinson to a friend of hers who was an employment lawyer, and the case went on from there. The trial was a horrible ordeal. This was before some revisions to the federal rules of evidence, where proof was introduced about what Michelle Vinson wore to work, other women co-workers, some of whom were having affairs themselves with Sydney Taylor, who knows if they were consensual or not, said sure her dresses were too short, her skirts too tight, her blouses too low cut. Things she had supposedly said about sexual fantasies were allowed into evidence. Conversely, Sydney Taylor's treatment of other women in the workplace was not allowed into evidence. This was just about between Michelle Vinson and Sydney Taylor, said the judge. And so not surprisingly, the judge found in the bank's favor. The case was appealed to the D.C. Circuit. And what was going on at this time around sexual harassment law was that courts had just in the last few years started to understand that what we call, as a shorthand, quid pro quo harassment, meaning male supervisor propositions, supervisor, but I just am speaking in generalizations. Supervisor propositions, subordinate says no, supervisor fires subordinate. Courts were just beginning to understand in the late 1970s and early 1980s, okay, if it affects your pocketbook, if it affects your bank account, you lose your job, you lose a promotion, or you're demoted, or your pay is cut, okay, that's discrimination. We can get that. It had taken them a while to get there. For a while they were saying this is just, clumsy courting gone awry, but they eventually got there. But by the time Michelle Vinson was coming forward, she didn't have any damage to her bank account. She kept her job. She was promoted. All she had was the degradation that she'd been through and the toxic work environment that she lived in every single day, that she was losing her hair and wasn't sleeping. And the company said this is not what the law is meant to address, but the D.C. Circuit and then the Supreme Court disagreed. And they said, and the Supreme Court borrowed from race discrimination law, borrowed from the body of case law that had been developed around racial harassment, where there was never any doubt that just because you didn't have a loss in pay or lose your job, if a noose is over your desk, or the KKK is carved into your desk, or you're called the N-word, that's discrimination. And so the Supreme Court was able to see that, and I'm really paraphrasing here, but having to face a gauntlet of sexual abuse every day is no different than the racial context. And so they found hostile work environment harassment to be discrimination. A later case that I also profile in the book was almost equally important, the Harris v. Forklift case decided in 1993, because in that case, the conduct in the Vinson case was criminal in many respects, and it set the bar really quite high for defining what was illegal harassment. The later case involved no physical harassment, no touching, just more of the sort of what we probably think of as more garden variety, unfortunately, leering and propositioning and commentary on clothing and so forth. It also had some not so romantic harassment, like calling Teresa Harris a dumb bitch, or what do you know, you're just a woman, that kind of thing, which also is within the sexual harassment rubric. So that was an equally important case a few years later, about a decade later, because it said that Vinson only set the outer limits of what's illegal, but it's not the starting point between legal and illegal. That bar is much earlier. As the court said in the Harris case, Title VII comes into play before the victim has a nervous breakdown. So on that note, I think I'd like to stop and take questions. I'm happy to keep chatting about those cases or others in the book, or anything else folks would like to talk about. But thank you all so much again for being here. It's incredibly meaningful to me to have you join me on this special day, the release date of the paperback. Anyone? Oh, there's a microphone. Oh, there's one at each side.
Oh, wow.
I think it's on.
I was just thinking that the situation was right at the court. You had the the justices at the court who were eager to listen to the arguments. What would you think if the court, the cases came up today to the court as it is? How would the outcome be? Would it be the same?
Oh, that's asking me to read those tea leaves is not nice. That's really hard to say. I mean, there are far more expert court watchers than I who can talk about the various personalities and how this court interacts. And, you know, for sure, there's a certain tenor that exists now under Chief Justice Roberts. I mean, what I will say is that there is a pending petition for the Supreme Court to take a case deciding whether sexual orientation discrimination is discrimination because of sex, and that petition is pending right now. And the case is Evans against, I think it's Georgia Memorial Hospital, and where the ruling below was that it is not. So I think that is being brought forward now because people fear Justice Kennedy leaving, and I think that's sort of my backhanded way of answering your question, which is that I think we are at a pivot point that is incredibly important and potentially catastrophic, frankly, for many, many of the things, many of the rights and the contours of those rights that are outlined here and that are adjacent in terms of women's rights. Anyone else? Hi.
Hi. So I'm also have kind of a hypothetical question, unfortunately, but I was just wondering if there are any downsides to the fact that this was just kind of a throwaway addition, and so a lot of the law has developed in the courts rather than legislatively or through advocacy, and, you know, has that posed any obstacles when you're litigating?
And I don't know if people heard in the back, because I'm not sure if this mic is on. With the question, that's okay. The question is whether the sex provision's last-minute addition has in any way posed obstacles to it being read as broadly as it possibly could, because courts have been the ones interpreting it. That's a really interesting question. I think in some ways it has meant that progress has been slower. Because we have had to have, you know, the fits and starts that litigation brings and all that. And, you know, for things to get to the Supreme Court, there has to be most often a circuit split, meaning that circuit courts have come out differently. So that period of uncertainty certainly harms people in the interim before there's clarity. But I think that the role of the EEOC has been really essential here. And after those kind of early missteps that I mentioned and sluggishness to address issues like they were very slow to address pregnancy, for instance, and what employers should be doing around pregnancy. After that initial sluggishness, and again, with the caveats that some administrations have been more vigorous than others, it has been a pretty strong forward motion pushing forward. And, you know, legislation is overrated in terms of it's clunky, you know, it's slow too. And, you know, I mean, look at the Family Medical Leave Act was enacted in 1993 for 12 weeks of unpaid leave, and that's the best we've been able to do since 1993. Like, nothing has happened since then, despite overwhelming public opinion. So I think I think legislation is actually a pretty blunt instrument, and with a strong EEOC and with some strong precedent that has settled many of the issues that we're dealing with, we're now fighting a lot more, frankly, about policy or about culture change than we are about advancing the law. The LGBT community, or that piece of it, as a, you know, an asterisk.
Thanks.
Anyone else? Hello.
I will confess I haven't read your book yet, so you may address this, but I was curious on your thoughts. I've been reading a lot both about Justice O'Connor and her own publications recently, and I feel like it's interesting because on the one hand, obviously being the first woman sitting on the court, she has a lot to say around equal opportunity and issues that you sort of touched on, like motherhood, and how there are real biological differences, and how do we address that in order to bridge the gap. On the other hand, making a lot of interesting points that she waited until after her children were out of the house to start her career, and that seemed to be a way that she made that balance. I'm curious where you see it going outside of people like Senator Gillibrand even today talking about paid family leave and things like that. Outside of that, where do you see it going in terms of actually bridging that gap versus maybe just having the idea that it would be great if women could do both, but not necessarily in practice or not necessarily for everyone?
So if I can summarize, the question is where is the law going and where is the workplace going when it comes to the sort of work-life balance, if you will? The questioner also asked or spoke a fair bit about Justice O'Connor, and let me just put in a plug for Linda Hirschman's Sisters-in-Law, which
Great book.
Yes, okay, well, so you've read that. So which is terrific, and it's about Sandra Day O'Connor and Ruth Bader Ginsburg as being the first women on the court, and their relationship and their different paths. This is one of those areas where we are in policy realm rather than an anti-discrimination realm, except as to motherhood bias, which certainly remains a very pernicious problem and needs to be addressed. My overall feeling about this issue of equalizing women's opportunities vis-a-vis having families is men. And that we need to get rid of, first we have to get men using policies like family leave to the extent private employers are using them. We need them to be advocating just as vigorously as women are, so that this is not constantly ghettoized as a women's issue, touchy-feely women's issue. It's a family economic issue. Women are the primary breadwinners in either sole or primary breadwinners in half the families in this country. And so making sure that having a child or being a mother doesn't kick them out of the workforce is of paramount importance. So I think having men use these policies at work to destigmatize them is going to put them on the front lines a bit. And we've already seen some cases where men have been discriminated against for utilizing paid family leave. Welcome, gentlemen, to our reality. And but I think definitely using the momentum from the Women's March, from all the everything that came out of the campaign of Hillary Clinton to enact real paid family leave that everyone is entitled to, gender neutral, is the next logical step.
Thank you.
Hi.
Good evening. I lived half of my life behind the Iron Curtain, where you could get any job if you could do it, and you got the same salary as a woman. But you had to fix yourself the sexual harassment situation, which I had to do on my first job as a physics teacher in a faraway village, where the supervisors thought that smart, young, and pretty, 25 years ago I was, could fall victims. But as a general approach, we did not have that.
Mm-hmm.
So it was rare, and he backed off because I put a nuclear bomb on him. What I want to ask, coming back to America, what is your impression, or if you run into cases where management was not the perpetrator, but used and invent accusations against the employees that they did not like, that they were the perpetrators?
So I'm sorry, what's the question about? Have I encountered that as a lawyer?
Yes.
I mean,
like in the movie with Demi Moore and
I don't like that movie.
Yeah, I did not either, but
it's very unrealistic.
And I did not refer to that because their stuff happened.
Mm-hmm.
But when the management would use the harassment story to hurt an employee because that employee did something that they did not like on something completely unrelated.
Mm-hmm.
like?
I mean, employers are very powerful, especially in this economy which is at-will employment unless you're in a union or unless you are lucky enough to have an employment contract. Employers do all sorts of things to get rid of people they don't like. In my experience, manufacturing harassment allegations is far. I've never had a case involving that. They're far more likely to do, frankly, the easier thing, which is to criticize your job performance. And it's really, really hard when you're not perfect, and no one is perfect. It's really hard to rebut those kinds of allegations that you especially when standards are subjective. For instance, when your job performance is not about how many widgets you make, but how good of a leader you are. It can be very easy for employers to manufacture that kind of a case, and I think that's far more common.
So yes, that was the question.
Hi.
Hi, you spoke a lot about intentional discrimination.
Oh,
and
yeah.
I wondered how effective you think Title VII's been when it comes to neutral rules that fall disproportionately on women or men because of sex.
Sure.
Sort of outside like height and weight requirements, but other neutral policies.
Oh, it's too bad you said outside of height and weight requirements, because that's what my chapter on neutral policy is about. But there are two kind of different discrimination under Title VII come in kind of two general flavors. Intentional discrimination, which is also called disparate treatment, and then disparate impact. And what disparate impact discrimination refers to is when an employer has a neutral policy, like a requirement that's addressed in the case in the book, that to be an Alabama prison guard, you have to be a certain height and certain weight. In this case, it was 5'3" and 120 pounds. To be a corrections officer, that has the effect of disproportionately screening out members of some protected group. So it initially was created a doctrine that was created in the race context, having to do with black workers at a power plant who suddenly were subjected to a requirement of taking an intelligence test that had no bearing whatsoever on the job they were being asked to do, and also a high school diploma requirement. And what the court has said in both of those settings, sex and race and any other disparate impact setting, is that it's okay for an employer to use these kinds of selection devices or screening devices, but they have the burden of showing that it's necessary to their business to do so. That this test, so for instance, the height and weight requirement, that they actually could show, that Alabama actually could show that prison guards who were of this height and weight performed better. And they didn't have that kind of evidence. There's been much more in the disparate impact realm around with women involving physical tests. So women trying to get into police departments or fire departments who have to take physical exams, run certain obstacle courses and things like that. And I think disparate impact is actually an underutilized mechanism for bringing out discrimination. And I think courts are very, very sensitive, especially in fields where women, for instance, are underrepresented, like policing or firefighting, are very sensitive to assuring that this test was made according to certain standards. The EEOC has some uniform guidelines about selection devices, that there is a strict correlation between the selection device and success in the job. And if you can't make that correlation and it's excluding people from protected groups, then the test isn't going to survive. So, yeah.
Could you talk about what would be the effect if the ERA were finally ratified on employment discrimination? Because I agree with you that progress through legislation can be slow, but could you talk about the strict scrutiny and the levels of scrutiny, and also with this kind of Congress, any legislation can be rolled back?
So the question was about what effect the ratification of the ERA, which has been reinvigorated in recent years, what impact that would have on employment law. So the employment law, Title VII applies to both private and government employers. The Constitution, which is what the ERA would do, would add an amendment to the Constitution to supplement the 14th Amendment, which has the Equal Protection Clause, would only apply to public employers. So school teachers, people who work for the post office, libraries, police officers. So that's one thing, is that it would only impact that slice of workers. The other effect it would have is trying not to get in the weeds here, but essentially when a state action is challenged. So when the post office denies you a promotion and you want to bring an equal protection claim, as a woman, the law is looked at by the courts according to an intermediate standard. So if you were bringing a race claim, the court would look at it under what's called strict scrutiny, the most exacting scrutiny. This action will not stand unless the employer can give an especially strong reason for why it acted in this way. And then every other kind of, aside from race, every other kind of characteristic is assessed at rational basis, meaning that it's very easy for the state actor to justify how it's acted. And so gender is right now in the middle at what's called intermediate scrutiny. The state has to have an exceedingly persuasive justification for how it acted. So what the Equal Rights Amendment would do would bring gender cases up to the strict scrutiny level. To be truly frank, I think the number of instances in which the ERA would make a big difference have dwindled, in part because of legislation that have filled in those gaps. One area where it has not is the area of pregnancy, where there's actually still a case on the books from 1970s where a woman in California challenged a state temporary disability program that the state had that gave benefits to people who were out of work for all sorts of reasons, all sorts of disabling conditions, but excluded pregnancy and childbirth. And the court upheld that policy as not being sex discrimination under the Constitution. And that is still on the books. So that certainly, I think, would be an obvious immediate target. But, the decision about how hard to push for the ERA is a really complicated one, because as enticing as it is in terms of being a fix-all, it takes such intense mobilization to make something like that happen. We saw what happened throughout the 70s in the first effort to get it enacted. In this current climate, there are decisions to be made about priorities. And I personally don't know if that is where I think the best use of our resources is in terms of collective action. There is so much to fight back against that's coming at us, and there's so much we want to achieve that has already proven so difficult, like paid family leave. So that's my sort of pessimistic answer about, which I know is not especially uplifting, but that's I'm conflicted about the ERA, and I think a lot of women's advocates are.
Well, I'm just more pessimistic than you are in a way, because I know that all those good laws can be gotten rid of so easily at this point. So.
I don't know how easy. I don't know how easy it is.
They're already doing it with civil rights, right? So, anyway, thank you.
Okay. Sure. One more question. Hi.
Hello. So, my question is, other than fear and or nervousness, why do you think it is that people find it difficult to respond to our current president when he openly, we talk about sex discrimination, we talk about stereotyping among women in terms of the ideas about what they wear, X, Y, and Z. This guy openly discusses women in terms of their physical appearance, if they are attractive to him, and how that qualifies them either to be in the room or not be in the room.
Right.
Why do you think it is that no one in the moment, and we understand, obviously, we're all not in the room when these things are going on, but why in the moment does someone not say, excuse me, that's inappropriate? Or just something as simple as that, because one of my concerns is that, you know, a lot of this history is fantastic and it's still going on, unfortunately. I know your last case takes place in 2015 in the book, but what does it do to our society when you have little girls watching what is going on and just seeing these things happen and nobody says anything in the moment? Nobody says anything. It's always afterwards, where then it's like, oh yeah, you see what he did today? Wow, that's wrong, right? Shouldn't happen.
Right. I mean, he's surrounded himself with sycophants, so I don't think there's much hope of people calling him out on what he's doing. But I think you've actually raised a point that I mention a lot when I talk specifically about the issue of sexual harassment in the workplace, and you know, which is still just everywhere, as the Fox News debacle has shown us, at the highest levels. And has gone on for years and was completely embedded in the culture. It wasn't just a couple bad apples or something. Mm-hmm. And we see it played out in the military. We see it in all sorts of male-dominated fields. You know, Silicon Valley obviously is another area where it's been an issue. And it's a struggle as an attorney trying to think about ways forward, because I think at this point the law, except maybe with respect to the issue of the internet and harassment and social media and that intersection, other than that, I don't think the law really has any place else to go on this issue. I think it's a cultural issue, and I think it's another one that does come back to men calling out men. You know, I talk a lot to women's groups and who bring me in to talk, and I'm kind of sick of women talking to other women about this problem. And so, I mean, obviously there are female harassers and there are male victims, unquestionably. But I mean, when we talk about the real, you know, embedded problem that you're raising, it's men and women. So I think there are two things. I think you're kind of doomed if you have someone at the top, like our president or like Roger Ailes, who's setting a tone. But otherwise, if you have people at the top who claim to care about this issue, it is a full-time job to be getting the message out that what zero tolerance really means, and then enforcing it, to not retaliate against people who bring complaints forward, to take action. This weekend, I met someone from the Paul Weiss firm that's been handling the Fox News stuff. They got in there, they did an investigation. Lo and behold, not Gretchen Carlson, the other blonde, Megyn Kelly. Suddenly she comes forward because you have someone coming in saying, "Tell us, we want to know," and they usually don't want to know. So I think having a message coming down from the top of what zero tolerance really means, following it up with action, but then also when women are not in the room, men calling each other out. I mean, it's called, you know, what's it called in psychology? Dead. It's like bystander something. Okay, yeah, I mean, bystander, you know, inertia of thinking, oh, someone else will take care of this. It has to be men speaking to other men and saying this won't fly. That's it's not. They're not going to listen to me.
Until an important wife is going to be in a situation so the husband is really upset at what you say.
That seems to be the only time a lot of these guys care about any issue that affects women, is when a wife or a daughter is affected. And I mean, I'll take what I can get in terms of, you know, they're taking action, but it's really a shame that it takes that to get them concerned about this issue. So, thanks. Thanks, everyone.